Assalamu alaikum. Okay, in this video, we talk about a mistake that is under section 20. So, if your consent is obtained from mistake, then it is also not a free consent. And what will be the effects on the contract if the consent has been obtained via mistake under the section 20? So, let's discuss. The first one is when both the parties to an agreement are under a mistake as to matter of fact essential to the agreement is void under the section 20. Like both parties are not in the same position and they are in a mistake regarding a subject matter or regard any fact that is essential to the agreement, then such agreement is actually void. Okay, because there is no consensus on a same object. So what are the types of mistake actually? The first one is mistake of Pakistan law. A contract is not voidable because it was caused by a mistake as to any law in force in Pakistan according to section 21. Okay, so if you've made any contract with anyone, such contract can be called as void ab initio. That word we have learned in the video of concern. Void ab initio, that is null from the beginning. Because if you have made any contract and suddenly after the contract you find out that the law in Pakistan forbid such activity, then such contract actually null from the beginning. That is voided ab initio. So that is not voidable from any side. That is void ab initio. That is void from the beginning. Again, mistake of foreign law. A mistake as to the law not enforced in Pakistan has the same effect as a mistake of the fact. That is void under the section 21. So if you're living in Pakistan and your friend is living in, let's suppose, Germany, and you have made a contract with him, and what you have to do is to perform your performance on Germany, but in Germany, such performance is actually prohibited. So again, such contract is also a void ab initio, that is void from the beginning, null from the beginning. So that is a void contract. Now, the third one is a bilateral mistake. Okay, when both the parties to an agreement are under a mistake as to matter of fact essential to the agreement is void. We have already knew that. And erroneous opinion as to the value of the thing which form the subject matter of the agreement is not to be deemed a mistake as to matter of facts. Okay, bilateral mistake as to the subject matter. Bilateral mistake as a subject matter includes the following mistake as to existing of subject matter, quantity, quality, price, identity, and title of subject matter. Okay, so first it has been written that if there is any bilateral mistake which is actually essential to the agreement, so such agreement is void. If you want to buy a civic car of your friend upon 2 million rupees, but your friend is willing to sell his civic at 2.5 million, but he also has another car that is new city and he's willing to sell this car at 2 million. So both of you feel that you offer him to buy his car at 2 million, but what you are actually doing it you are willing to purchase his Civic that is of 2.5 million. On the other hand, your friend feels that it's okay. He is willing to sell the car to yourself, but he feel that you're willing to purchase a city. So you both are actually doing a mistake. That is a bilateral mistake because the price of subject matter, identity of subject matter, title of subject matter, you both are in a bilateral mistake. So such agreement can be called as a and it has been declared as a void agreement under the Contract Act 1872. Now, the unilateral mistake, where one party is actually in a mistake and another party is not. A contract is not voidable merely because it was caused by one of the parties to it being a mistake as to matter of fact under Section 22. Okay, let's suppose in a contract for the sale of screws. Okay, in a there's a contract. One party may incorrectly believe that the word screw refer to a specific brand of screws that, for example, Phillips head screws. So when in fact the term really means any standard type of screw, thus if only one party holds this mistaken belief, but the other party is clear concerning the meaning of a screw, then it could result in a unilateral mistake dispute. So on the other hand, if both parties believe that the word screw actually mean nails, then this would be an example of mutual mistake. So in addition, unilateral mistake also frequently involve prices, quantities, dates, and errors pertaining to the description of goods or services, including in the contract. So, what are actually the effects? So, a court will usually issue one of two of the following remedies. The first one is the rescission, and the second one is the reformation. So, if contract rescission has been granted, so it is a remedy that completely cancels the contract. And purpose of this remedy is to restore the parties to the position they were in before the contract was formed. But if they granted a reformation, then the agreement, written agreement, is changed to reflect the parties' original understanding of the terms of the contract. So reformation is typically reserved for mutual mistake, but it will be granted for unilateral mistakes. Okay, only in such cases where one party was mistaken, but the non-mistaken party was unaware that the other party was confused. So this is all about the unilateral mistake, but there are some exceptions. Following are the exceptions where agreement is void on the basis of unilateral mistake, mistake relating to the identity of the person or to the nature of the contract. If there is an agreement that he want to perform he that he's going to perform his performance to Mr. Asim, but suddenly he find out that this is not that Mr. Asim to whom he is willing to perform because or bind himself into the contract. So there is a mistakenly unilateral mistake. Similarly, the nature of contract as well. So it is all about the mistake. Thank you so much. Allah Hafiz.